All right. Good morning, everyone. Thank you, Larry. My name is Marty Rabinovitch. I am the head of the Employment Law Group here at DSF. I will be speaking to you this morning about two topics, the first of which is Bill 148, the Fair Workplaces and Better Jobs Act. So in this presentation, we'll start with some of the background, and then we're going to look at some of the specific amendments. So we will look in particular at the amendments surrounding equal pay for equal work, which have now been in force since April 1st of this year. We will look at the new legislation about scheduling, which is actually not yet in force, not until January 1st of 2019. So there's still some time there to plan and prepare for that. And then we will look at the new types of leave. Those are already in force. They've been in force since January 1st of this year. And then we will conclude the presentation. So Bill 148 has been passed into law as of November of 27. It's now called the Fair Workplaces, Better Jobs Act. And the Fair Workplaces and Better Jobs Act amends a whole bunch of employment statutes, one of which is the Employment Standards Act 2000. The change that was probably making the news the most was about the minimum wage increase. So as a reminder, it's currently $14 an hour for minimum wage. That number is set to increase to $15 an hour on January 1st of 2019, although who knows, that may change depending on what happens in the next provincial election here. But as it stands now, it will be $15 an hour in 2019. But aside from minimum wage, of course, there are a whole bunch of other changes as well. So let's get right into equal pay for equal work. So it is now prohibited for an employer to pay a different rate of pay to an employee because of a difference in their employment status if those employees are performing substantially the same skills. So when we're talking about employment status, what we mean is a full-time employee, a part-time employee, a seasonal employee, and so on. So for example, if we take an example of a bookkeeper, a part-time bookkeeper and a full-time bookkeeper would now have to be paid the same hourly wage if their duties are substantially similar. And employees are now able, and if the employee believes that their rate of pay does not comply with the act, they are now able to ask the employer to review that rate, and then in response, the employer can adjust the pay rate. Now, to be clear, they have to be adjusting the rate up. They can't solve this problem by reducing anyone's hourly rate. So the employer can adjust the hourly rate, or they can provide the employee with a written response explaining to the employee why the employee is wrong and why the employer is right and why they're complying with the act. There are some exceptions to the equal pay for equal work provisions, and the exceptions are now set out in the legislation. So the exceptions are seniority, a merit system, a system that measures earnings by quantity or quality of production, and any other factor other than sex or employment status. So, for example, if we go back to our bookkeeper example, if we have a bookkeeper who has 20 years of experience and has the title of senior bookkeeper, and then we also have a very, very junior bookkeeper who only has 6 months of experience, and it just so happens that they are performing substantially the same duties, those two employees would not have to be paid the same hourly rate because of a seniority system. One is clearly more senior than the other. So there are some exceptions to this. If an employment standards officer determines that the employer has contravened these sections of the Act, not surprisingly, they can order that the employee be paid the amount owing, and this amount would be treated as unpaid wages for the purpose of collections. Now, one interesting note about any unionized employees, so if you're a unionized employer out there, this is important. So if you happen to have a collective agreement that was in force prior to April 1st, and the provisions of that collective agreement actually contravene these equal pay for equal work provisions, it's actually the collective agreement that is going to take precedence. Usually the Employment Standards Act tends to take precedence over everything, but in this particular case, it's actually the collective agreement that would prevail. So, important note for unionized employers out there. Employers are prohibited from intimidating, dismissing, or otherwise penalizing an employee because the employee makes inquiries about the rate paid to another employee for the purpose of determining whether the employer is in compliance with these provisions. And it's also prohibited for the employer to discipline an employee for disclosing their rate of pay to another employee who was making the inquiry to get to the bottom of whether the employer is compliant with these provisions. Okay, so we will now move on to some new laws about the scheduling of employees. And again, those do not take effect until January 1st of 2019, so there still is some time to plan and prepare for that. So for starters, an employee who has been employed for at least 3 months is now allowed to send a written request to their employer and ask the employer to change their schedule or their work location. And when that happens, the employer now has an obligation to discuss that with the employee within a reasonable time. Of course, there's really no guidance on what a reasonable time is, but there you have it. If the employer decides to grant the change, the employer needs to write to the employee and explain what the changes are, when the effective date is going to be. And if the change is going to be denied, the employer has to explain why. Now, we don't really have much guidance on this yet, mostly because they're not yet in force. But presumably, if an employee were to get hired in, say, Mississauga, and then 3 months and 2 weeks later, the employee says, "Well, I live in Toronto. Can you please transfer me to our Toronto location?" And the employer writes back and says, "No, you were hired in Mississauga. We don't need anyone in Toronto. We need you in Mississauga." Presumably, that would be good enough, unless the court starts saying otherwise. An employee who regularly works more than 3 hours per day and is required to come to work, but then ultimately works less than 3 hours of work because the employer sends them home early, would be entitled to the greater of 3 hours at their regular rate, or the sum of the employee's rate while working plus the remaining time calculated at the regular rate. So, for example, if an employee is scheduled to work and ends up working 2 hours of overtime and then gets sent home early, well, now they're entitled to the 2 hours of overtime plus a third hour at their base rate of pay. So in this particular example, it's actually the second bullet point up there that would apply. Employees now have the right to refuse a request or demand by the employer to work or to be on call on a day where they are not scheduled to work if the employer makes that request less than 96 hours, or I guess 4 days, before the start of that shift. The employer is not allowed to discipline or otherwise sanction the employee for that refusal. However, there is an exception here. If the work is necessary to deal with an emergency, then the rule doesn't apply. And by emergency, we're talking about things like public safety threats or the delivery of essential public services, natural disasters, and so on. Now, an employer who cancels an employee's entire scheduled day of work or scheduled on-call period within 48 hours before the period now has to pay that employee 3 hours worth of regular wages. So if an employee is told by their employer that you must be on call, you must be prepared to come to work if I call you. And then within 48 hours, the employer says, well, actually, no. Now that employee is owed for 3 hours at their regular rate. All right. And similarly, if they were scheduled to work a whole day, then the whole day gets canceled. It's the same problem. Now, there's an exception to this as well, and the exceptions primarily relate to weather-dependent work. So for example, if we take a golf course and there's lightning and thunder and horrible rain, and the course is not going to be open because clearly no one wants to golf, okay, that would likely fit into this exception. So if there were employees who were scheduled and the employer is going to call in the morning at 6 a.m. and say, you know what, look outside, don't come to work. If the exception is weather related, then this wouldn't apply. Okay, but if there's no exceptions, then it does. All right. Okay, I want to highlight now some of the changes to the Employment Standards Act leaves. So there actually are, believe it or not, more leaves than what are on this chart, but these are some of the main ones. So the left column is the length of the leave in the pre-Bill 148 regime, and the right column is the amounts of time that the employee can take for these leaves after. So I just want to highlight a couple of things here. So if you look at the last two leaves on this chart, the domestic or sexual violence leave and then child death leave, those two leaves are actually entirely new. They did not exist in the pre-Bill 148 regime, so those are new. Note as well that for the domestic and sexual violence leave, that a lot of time, the employee could be entitled to a lot of time off for this leave, and the first 5 days are actually paid if the employee qualifies. So that's important because most of these leaves are unpaid. So that's one of them that's paid. And the other big one that you'll probably be dealing with more often as an employer is right in the middle of the page. That's a personal emergency leave. So in the post-Bill 148 regime, employees are entitled to 10 days of personal emergency leave. That is the same, but now the first 2 days of that leave are paid for all employees. So in the pre-Bill 148 regime, this only applied if the employer had at least 50 employees. Now that doesn't matter. Now with all employees, the first 2 days have to be paid, and the kicker is that now for these 10 days, the employer is not even permitted to ask for a medical note or a note of a qualified medical practitioner as it's set out in the Employment Standards Act. Okay, after the 10 days, if the employee wants to be off because of sickness, then it's not technically personal emergency leave anymore. So then the employer could presumably ask for medical documentation. But for those first 10 days, you really can't ask for medical documents. The Act does say that you are allowed to ask for what they call other reasonable evidence, although it's not really sure what that, it's not really clear what that actually means. I don't know. Are they looking for the employee's friend to call in and say, yeah, I'm standing next to him right now, I swear he's sick. But so we're not totally sure on that one, but that's the way the statute is worded. So in conclusion here, this one is really all about compliance. So for employers, you just want to have your workplace audited, check the policies, make sure that you're in compliance with the new employment standards that are already in force, and get going if you haven't already with respect to planning for the new standards that will come into effect on January 1st of next year. And another good tip as well would be to update your employee manual. So in particular, if you have in your employee manual already references to leaves and holiday pay and all that sort of thing, if you already have the information in there in particular, it is important to go through your policies and update it to make sure that your employee handbooks are accurate, because it's going to cause confusion if you don't do that, and then employees start asking you about Bill 148 entitlements. Okay, So that concludes the presentation on Bill 148.